Good afternoon, class.
Good afternoon,
I
sir.
want to believe our day is going on perfectly well. Welcome to today's class. I hope you can hear me. Please kindly confirm that you can hear me.
Yes, sir.
I can hear you, sir.
Hello, I can't hear anybody. Can you hear me?
Yes, sir, we can.
All right, okay. Just a minute. All right, sorry for that break. So today, by the grace of God, we are going to continue from Topic 3, which I briefly introduced yesterday, and the topic is sources of Nigerian law. Sources of Nigerian law. And we're going to start by having an introduction into what we mean by the sources of Nigerian law. Now, the term sources of law, among others, means or is used to refer to the fountain of authorities of a rule of law. That is, the origin from which a legal rule derives its authorities from. So, it is the foundation of that particular law, or where it took its authority from. And that's what we mean by sources of law. That's in one breath. We can also have other meaning on the same subject, as we shall see as we make progress in this class. But the first thing we're establishing this afternoon is that sources of law means the fountain of authorities of a rule of law. I'm talking about the foundation where a particular law derives its authority from. And also, by the phrase sources of Nigerian law, we mean the origin of the whole body of Nigerian legal system. The first part we looked at, which is sources of law, can apply to any jurisdiction, not necessarily Nigeria alone. But if we're applying to any jurisdiction, the general meaning that we have ascribed to that concept, we apply. Because, for example, the law of South Africa, a particular law may have a different origin from another. But the old system of law in South Africa can also be traceable to a particular source. So also is the case of the Nigerian law. So when we talk about the sources of Nigerian law, we're talking about the origin of the whole body of Nigerian legal system. That is where Nigeria law is obtained from. So this place where Nigerian law is obtained from is what we mean by the sources of Nigerian law. So in that case, we will know that this source alone is particular to the Nigerian people or to Nigerian law, as the case may be. So consequently, we can say that the sources of Nigerian law are the places where Nigeria derived its own law from. And it can also connote or mean the materials that contain Nigerian law. The materials that contain Nigerian law and the origin from which a legal rule derives its authority. And you notice that we have moved from the premise of just the origin to talk about the material, which can be anything, which can be from a document, so-called, maybe with a special name given to it, but which serves as a foundation to the law that is in question. So, the source of Nigerian law are not only local. That is the first thing you also need to put in your mind this afternoon, that the sources of Nigerian law are not only local. By reason of our history, you know that we have connection with our colonial heritage. And following the connection, we discover that we cannot but refer to that connection, because indeed most of the laws that we have are gotten from the colonial masters, or from, all the countries or the people as a nation that we have had interaction with at one point or the other. So therefore, we'll see that by reason of the imposition of British rule in Nigeria between 1861 and 1914, we cannot in any way separate our heritage or separate our, a particular origin or the origin of our laws from the English people. So, by this period that we're talking about,
Good afternoon. Good afternoon. Good afternoon.
just a minute, please.
How are you all doing? Hello. Hello. Hello, sir.
All right. So, English law was introduced into different parts of Nigeria at different times by series of proclamation and ordinances. If you follow our conversation when we were looking at the post-colonial justice system in Nigeria, you will observe not even the post. During the colonial era, you will see eras of proclamation by various ordinances establishing different courts at one time or the other. And then all of those proclamation ordinances, one way or the other, brought some form of law into our system. So, by virtue of this history that we have with the British, we took the English laws as part of the sources of our laws. Maybe at the earlier level, you were told that even some of our laws were practically carried or lifted from the provisions of the law of other nations. And the only thing that we did was to edit part of it, probably where their name appeared, and replace them with our own name, just for the purpose of our identity. So therefore, we need to know that that relationship also mean or talk about our history, and then whatever we have today also is an offshoot of whatever our history, was at a time. Then we are also going to look at our, customary and Islamic law, because one of the major sources of our law as a nation was from the custom and the way of life of the people. And that's why in our previous submissions and discussion, we've always established that before we were colonized, we had our own system of law working perfectly for us. So all of those customs and rules form also the foundation of our legal system. So we are going to identify these various sources, and then as time progresses in the course of the lecture, we discuss them one after the other. Now, we're going to start with number one, the Nigerian legislation. It's number one of the sources that we're talking about here. Number two is the received English law. The received English law is another source of Nigerian Nigerian law. Number three, we have case law. Number four, we have customary law. Number five, we have Islamic law. Number six, we have international law. And the seventh that we are going to look at is the opinion of jurists and legal writers. I'm going to, recap on these sources that we have listed so that we can have all of them in our mind. And then by the time we are discussing them, it will flow from one to the other. So the first one, I repeat, is Nigerian legislation. Number two is received English law. Number three is case law. Number four is customary law. Number five is Islamic law. Number six is international law. And on number seven, we have opinion of jurists and legal writers. All of these we will look at as a unique and subtopic as we make progress in the course of our lectures this semester. But we are going to start with the first one, which is the Nigerian legislation. That is the first, one of the first sources that we are going to look at. So we'll take the subtopic Nigerian legislation. Now, when we talk about a legislation, it can also refer to as statutes. Okay, so a legislation is also referred to as statutes, and this is a kind of law enacted by a legislature and usually in a written form. So the number one point on this Nigerian legislation is that it is a law enacted by the legislature, that is, the arm of government that is saddled with the responsibility of law making. And then when we have such, we refer to it as a legislation. And usually, or one of the major characteristics of this type of law is the fact that they are written, properly documented, and they can be seen by all. they can be, engaged on like customary law as a source of law that is largely unwritten, that you cannot find in a single document. But legislation are, in the opposite, are laws that are in written form. Also, legislation in Nigeria are enacted or made by the national or state houses of assembly. Okay? Legislation that we have in Nigeria, they are enacted by parliament, by either the National Assembly, which in our own case comprises of the Senate and the House of Representatives. Laws are made in these two houses, and when they are enacted, of course, that is after they have followed the required due process of lawmaking, and then they come into being and they become laws for the country, which every individual that finds himself within the territory of the Nigerian circle is duty bound even to obey. So, laws enacted by the House of Assembly admit and pass through the prescribed legislative process or procedure. So that is to say that before a law can be enacted or deemed to have been enacted, such law must have passed through what is largely referred to as the legislative procedure. In the course of this class, we will digress at a certain point to look at this legislative process or procedure and also be part of it so that we can have a better understanding of what we mean by the legislative procedure. Now, legislation is a powerful and exigent source of Nigerian law. We need to take note of this very seriously, that legislation as a source of Nigerian law is a powerful and exigent source of our law as a nation, because it is a deliberate exercise of law-making powers. Okay? It is a deliberate exercise of a law-making power by a persons or persons legally or constitutionally empowered to do so in a particular setting. When you look at the National Assembly, the senators are, elected to, part of one major primary role they have to play is to make law for the country. So also are the legislators are, elected at the state level. They are duty bound to, come up to propose a bill that consequently leads to a law. And when such laws are passed and endorsed or assented to by the governor at the state level, it becomes a law. Also, when such proposal becomes a law, and then the president of the country gives his assent, automatically such law is deemed to be a valid law. So any persons that is legally or constitutionally empowered to make law can come up with a legislation. And that's why we're saying that when they come up with the legislation, we are saying that it is a deliberate exercise of the powers that have been vested in them. And like I said, we see example in the National Assembly and also the state houses of assembly. Now, the Nigerian legislation is generally viewed as the most important instrument of legal development and a source of Nigerian law. I'll repeat that again for emphasis because of how important it is. I said that Nigerian legislation is generally viewed as the most important instrument of legal development and source of Nigerian law. Now, Nigerian legislation has tremendous effect on all other sources of law in Nigeria, in that it can readily alter their content, it can alter their application, and can even go ahead to repeal them. That is, to cause them to cease to operate as a law within the Federal Republic of Nigeria. Also, why we say that the Nigerian legislation is generally viewed as the most important instrument of legal development and a source of law is that all other sources of Nigerian law are, ascribed validity by virtue of one piece of legislation or the other. Let's take the Nigerian Constitution, for example. The Nigerian Constitution only has the power to approve the domestication process of any foreign law that the nation intends to make to be binding on the Nigerian people. So meaning that the Nigerian legislation is the overall of it because of its enormous powers and the fact that it can create law. It can also kill law. Use the word kill because once a law is repealed, that law, for all intent and purposes, is dead. So the law, Nigerian legislation, can or gives validity to every other law in Nigeria. As a matter of fact, sometimes even the Nigerian legislation can invalidate the customary law for whatever reason that it may provide. Just a minute, please. So, with that alone, we'll see that the Nigerian legislation is very powerful because it is the enabling law for other laws within the territory of the Federal Republic of Nigeria. Now, what are the types of legislation in Nigeria? What are the types of legislation in Nigeria? Now, just by way of, an aside, I've constantly monitored this class, and especially those of you that are on board now, you may share with your colleagues. This class is a class that is very large, but for quite some time now, I've noticed that the attendance will always show 239, 238, 240, and so on and so forth. And then when an activity is to take place, people come up with all sorts of lies to say they were there, they were logged out, they were this, they were that. For your own interest, always attend your lectures. I'm not in a position to say more than that, but I believe that a word is enough for the while, because those who are here today may not be here tomorrow, and then they are playing, the times away, and then probably they feel that they could approach us to tell us that the system logged me out, this and that. Please take your lectures seriously. I do not see why a class of about 400 students should not be filled to capacity. But I will just leave that comment there. And I think those who have ears will take the advice that has been provided. Now we continue with our lecture. Types
Interrupt. Sorry, sir.
Yes, please.
Sir, please, what material have you been using to teach after idea of law?
I don't understand your question.
Sir, please, what material are you using to teach?
We did give you the recommended test, isn't it?
Okay. Yes, sir, you did.
Yes, all that I'm saying, are they not there?
Oh, thank you, sir.
Answer my question. All that I've been teaching you, are they not there?
I'm not sure, but I know the beginning part is there.
Who is speaking? What's your name?
Oluwadara.
Oluwadara, do you know your list of books for this course?
Yes, I do. Obilade and Asin.
And what? And I'm saying,
Asin.
okay. Now,
Yes,
how many of
yes,
those,
sir.
how many of the two do you have?
I had Asin, but I had to return it to the person that lent it to me
Why?
because the person requested that I did.
Okay.
So I'm waiting to get mine, sir.
Okay. Because the money you use to buy, I'm saying, is not up to the money you use to do data subscription in a week. And aside that, one other thing you need to know as a student is that you are not limited to a particular test. It's difficult for you to pinpoint which materials I'm teaching from, because I've read about 5 different tests on one topic from different authors. So you also, as a student, you are duty bound. Apart from those tests are the basic. You will also see the likes of Ezemalemi, you see other textbooks. Ebiowe Toby is also another one. Nigerian Legal System, Ebiowe Toby. These are good textbooks, but if we ask you to buy all of them, it may look as if we have vested interest in all of those tests. But whatever I'm teaching you are products of many textbooks, product of research, at least to do you some form of favor if you are not able to get all the textbooks at the same time. But at whatever rate, you're supposed to have as many tests you can have on a particular subject. It will broaden your knowledge and make you vast on the topics. Okay? I hope I've been able to answer your question now so that you go and get other textbooks. and maybe for once, you use your lunch, that your special lunch money to buy one. Are we good?
Yes, sir. Thank you, sir.
All right. So we talk about types of legislation in Nigeria. Number one is ordinances. Ordinances. This is one type of legislation in Nigeria. Now, what do we mean by this? Ordinances are those statutes which were enacted by the Legislative Council, which then legislated for the whole of Nigeria until 1954, when regional legislatures were introduced. Now, before now, as we went through the historical development of the Nigerian legal system, we referred severally to ordinances. We also refer to the British Council or organ that made laws for the country while Nigeria was still under the colonial influence. So all of those laws made as at then are what are classified as ordinances. So I repeat again that ordinances are statutes which were enacted by the Legislative Council, which then legislated for the whole of Nigeria until 1954, when regional legislatures were introduced. And of course, when the regional legislatures were introduced, they started making laws for the various regions, and then they were no longer referred to as ordinances, because ordinances was not a name that was, that the Nigerian system called their law. But for the purpose of this class, ordinances are those statutes which were enacted by the Legislative Council that was in charge of making law for the country at prior to 1954. So that is one of the types of ordinances or types of legislation in Nigeria. Mind you, some of these ordinances are still in our system. Some of them are still in our system. As a matter of fact, some of the laws that we practice can also still take their roots from these ordinances. And that's why when we're talking about the history of the Nigerian legal system, we at some point refer to ordinances as parts, as enabling laws as at then. Of course, they feature mainly in the establishment of Supreme Court, repealing maybe an earlier established court, and setting up another. So they are laws on their own. Another type of legislation we have is acts. A-C-T-S. A-C-T-S. Acts. Acts are federal laws enacted by the federal legislature. Now, the federal legislature here, we mean the National Assembly, that is the Senate and the House of Representatives. The Senate and the House of Representatives. We call them the red chamber or the green chamber. Now, any law that is enacted by the federal legislature is an act. And when such laws are made, they apply to every part of the country. As a matter of fact, because of the we have different lists in which different legislative items are provided for. We have the exclusive list, we have the concurrent list, and the residual list. Any item that falls under the exclusive list, they are dealt with at the federal level. For example, in Nigeria, we have Administration of Criminal Justice Act. That is a law made by the federal legislature that applies to every aspect of the country, meaning that if any individual violates anything or to do an act or exhibit a conduct that law has criminalized, it can be dealt with by the instrumentality of that law, which is the act, that is the Administration of Criminal Justice Act. We also have other types of acts like the NDLEA Act, the acts enabling the NNPC, even the University of Lagos Act is also a federal law made by the National Assembly. And the implication of this is that these are issues that pertain to the executive list. So an act is another type of legislation in Nigeria. But mind you, the fact that the law, the document or the particular legislation is referred to as an act does not mean that it cannot be technically referred to as a law. Whether a subject or a particular legislation is called ordinances or acts, they are all still laws. But the reason why the names are introduced are for some specific purposes, which I believe you understand in the course of time if you do not know already. So the second type of legislation in Nigeria is the Act, ACTS. The third is laws. Laws. And laws, just like we have legislation made by the National Assembly, laws are state laws enacted by state legislature under a civilian government. Laws are state laws or legislation made by the legislature, the state legislature, under a civilian government. As when you look at it in contrast with the Act is also made by the legislature, but at the federal level. Now we move on to another type of legislation, which is decrees. Decrees. They are laws also made by the central lawmaking body under a military system of government. They are laws made by the central lawmaking body under a military system of government. Why under the state military, we refer to them as edicts. So the fifth type of legislation in Nigeria is edicts, as in EDICTS. These are laws also made by the law-making body of a state or a federating unit or region under a military system of government. So when a system, when a law is made at the state level under the military regime, that or those kind of law are referred to as edicts. Just like you have laws, they are those made by the legislature at the state level during during civilian rule. Now, the other type of legislation we have is bylaws. Bylaws, as in BYE laws. In some text, you will see BY-law. But what does this mean? Bylaws are also referred, like I said, are also referred to as bylaws. They are laws enacted by local government council in areas within their competence. That is, in areas within which they have been saddled with the responsibility to make laws. Just like we know that the various levels of government have different duties that they perform for the running of the society in general. So we have the bylaws, which are laws made or enacted at the local government level by councillors. Councillors at the local government council. But one thing you notice in Nigeria is that practically all of the legislature, whether found at the National Assembly, state houses of assembly, or at local government level, are referred to as honorables. So those people who occupy those positions are fondly referred to as honorable members of those houses that they belong. And mind you, irrespective of all of these laws that we have talked about, each of the bodies that are saddled with the responsibility to make these laws make the laws in accordance with the items that they can legislate for. Issues relating to national security, it's a matter of for federal. Also, the state also can also venture into it because security cuts across all. But when you're talking about issues relating to market rates, situation of market, all of those are particularly local. And then the local government council makes law for such. Now, the Constitution of the Federal Republic of Nigeria regulates the distribution of legislative powers between the National Assembly, which has power to make law for the Federation, and the House of Assembly for each state of the Federation. Okay? The Constitution of the Federal Republic of Nigeria regulates the distribution of legislative powers between the National Assembly, which has power to make law for the Federation, and the House of Assembly for each state that is empowered to make law for those states. And the Constitution has already provided for what the National Assembly can make laws on, as against the ones that the state houses of assembly can also make laws. Then also, there's also another list that even the two of them can also make law on. But what we are saying in essence is that the Constitution has provided for those aspects that those different houses can make laws. Now, one other important thing that we need to discuss under the Nigerian legislation as our #1 source of Nigerian law is what is known as delegated or subsidiary legislature. Delegated or subsidiary legislature. Now, when we talk about subsidiary legislation or delegated legislation, we talk about laws enacted in exercise of the powers given by the statutes. Okay? We're talking about laws enacted in exercise of the powers given by the statutes. There are laws that are made by bodies other than those constitutionally recognized to make laws. Now, to break it down, I give you an example with the University of Lagos Act. The University of Lagos Act is a law made by the Federation or made by the National Assembly. When you look at the provision, one of the provisions of that act is that the act enables the university or empowers the university to make statutes, meaning that University of Lagos has been given power to make statutes where there is need. And when UNILAG decide to exercise these powers, what UNILAG is doing is that it is exercising the power that has been given to it, which is popularly known as delegated legislation. Okay? So, yes, those laws that are now made are now referred to as subsidiary legislature or subsidiary laws because they came into being by reason of the fact that the overall law has given such power to the entity to do so. You will see the Court of Law in Nigeria developing or enacting rules of courts. Apart from that, you also see several other bodies, either the NDLA Act, the which other body comes to mind now? All of these statutory bodies are empowered to make, if they are empowered to make some laws, whatever law they make, in the running of their establishment, they are generally referred to as subsidiary legislation. Now, it is the legislation by some administrative persons. That is another meaning that we can ascribe to delegated or subsidiary legislation. It is a legislation by some administrative persons, authorities, body, or agency under a power given by a statute which permits such administrative body or authority to make laws. Some examples of administrative authority include the President of the Federal Republic of Nigeria. The President of the Federal Republic of Nigeria is not a legislator, but by virtue of his office, the law of the land, the supreme law, has given the president powers to also make some laws in the course of discharging his duties. That's why you hear of executive orders, which once it is issued, you cannot go against them. So the President of the Federal Republic of Nigeria is an administrative authority. The same goes for the governor of the various states in Nigeria. Even the Chief Justice of Nigeria and the Chief Judges of states, also, even ministers, commissioners, government ministries, and departments. That's why you see that they are also able to make laws for the various entities that they represent. So this is the gist about the Nigerian legislation as a source of Nigerian law. And you can please start putting your attendance in the chat box, because we will be bringing the class to a close at this time after we have taken some questions. So by the time we reconvene again, we shall deal with legislative procedure or processes to give us understanding of how these laws are made. So I'd like to open the floor for any question or contribution that you may want to make. Over to you, class.
Question, sir.
Yes, please.
Right. Under the rule of ultravirus, the president as that is way and above what the Constitution of Nigeria states. How does he apply? What rule applies there?
I think your connection is now better. Can you recap what you've said?
What I've said is under the administrative power of or using the executive order by the president, right? Now, if it goes against the Constitution, is it not going to be a kind of ultravirus? If I'm right about that.
You've answered it. Once the powers that have been given is exceeded, every other action done by whosoever is ultravirus.
Okay.
Yes.
All right.
And that's why even when the president makes such law, he can't be challenged because he's already gone outside the authority given to him. Yes.
Okay.
Can we have it?
All right. Thank you, sir.
You're welcome.
So I have a question.
Go ahead, please.
So I don't see how the Constitution of the Federal Republic of Nigeria is a legislation, because based on constitutional history that we did in cons law class, the people that made the constitution, the Nigerian constitution, is not like a formal, is not It was not the National Assembly that made it, or that do you understand what I'm saying?
So who made it?
So the Supreme Military, it was not the National Assembly. I
You
don't
said
know who
what?
made it.
You don't know.
It was not the National Assembly.
If you are going to ask a question, you need to be very sure of the question you're asking. Now, let me take you from that point. Let's even assume that the constitution was, because I think because of what you hear, that the constitution was foisted or was just imposed on us. But are you aware that even the current National Assembly, by following due process, can repeal that law and make another to stand in its place and say, this is our constitution. Just the way part of this constitution we're talking about has been amended severally. If they've been amended severally and they are guiding Nigeria as a nation, then you cannot say it's not our laws. If there is any part of that constitution that is not servicing us as a people, it would have been taken off by the people who have the power to do so. So every now and then you hear, okay, now when we want to describe the Constitution of the Federal Republic of Nigeria 1999, you hear as amended. When you hear as amended, the question then is who amended it? If the story you have heard before is that we didn't make the law, but we have been using the law, we have been changing part of it, you have accepted it as your law. The day we know that because we have accepted the constitution as our constitution and start thinking of how to make it better, is the day we start getting it right. So whatever you are told that it was the military who did this, who did that, and we have been running military regime, the civilian regime for many years now. The National Assembly can as well, or through the collaboration with all other parties that are supposed to make law, come up with a new constitution. But as long as this is still in existence, it is still law made by the National Assembly. Any other question? Or was I able to answer your question properly?
Thank you, sir. Yeah.
Okay. Okay, so
Good afternoon, sir.
yeah, good afternoon.
Sir, I just want to ask that is there any section in the Constitution that gives a broader, like a clearer view on delegated legislation? Or is it just a concept that exists outside the Constitution?
I cannot tell you a specific section now. But when you look at Section 6, for example, the Constitution provides that the judicial powers of the Federation shall be vested in the judiciary. By virtue of that pronunciation or pronouncement, the judiciary automatically have power to make administrative laws, to make the power that have been vested in them to be effective. Let's say, okay, the Constitution only established the judiciary. What about the rule of practice that are being turned out by the state chief judges as are when due? So some of those provisions gave some consequential powers that the occupier can also exercise. Okay?
Okay, sir.
All right.
Thank you, sir.
Thank you very much all for listening. We'll convene again at the next class. Enjoy the rest of your day and God bless you.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Yes, sir. Thank you, sir.
Thank you, sir.
Ó ti tó now.